during the last 20 years, the court has been called upon to rule on an increasing number of cases which raised human rights questions from the biomedical field. For example, in the case of Pretty versus the United Kingdom, the applicant, Mrs. Pretty, who was suffering from a terminal illness, complained about the British authorities' refusal to promise not to prosecute her husband in case he assisted her to commit suicide. The court found that there had been no violation of the European Convention on Human Rights, as the right to life did not imply a right to die. Since then, the court has developed a substantive body of case law relating to the end-of-life situations. Of course, new questions arise, especially in the context of artificial procreation techniques. We have several cases which concern the question how a frozen, cryopreserved embryo should be treated in case things do not go as originally planned. For example, in the case of Evans versus United Kingdom, the intended parents split and Mrs. Evans, former partner, objected to the use of the embryo which had been created in vitro. In another Italian case, the Parillo versus Italy case, Mrs. Parillos, having tragically lost her husband, did not wish to continue fertility treatment without him. Instead, wished to donate the embryos to scientific research, but the Italian law did not allow for this. These are just a few examples. Other relevant areas would be also important, such as surrogacy arrangements. And also we have cases concerning the protection of genetic data, such as S and MAPA versus the United Kingdom. But we have many other cases. Even more and more cases are coming concerning this particular field. So this is a very topical field for the court. This convention is an extremely important piece of legislation worldwide. It's a unique convention, and our court is very open in this field. We often cite and refer to other conventions in the human rights field and beyond, and this is one of those conventions. We have done so quite a few times. For instance, in the case of Glass versus United Kingdom back in 2004, which concerned questions of parents' consent to the medical treatment of a seriously ill child. And in this case, the court systematically refers to the relevant provisions of the Oviedo Convention and relevant work of the Committee on Bioethics. In other cases, also in the Lambert case, the Grand Chamber of the Court referred to the guide on the decision-making process regarding medical treatment in end-of-life situations. And I could also mention a third example, the example of Konovalova versus Russia, where the court referred to the Oviedo Convention when it came to the question of a mother's consent to the presence of medical students during the delivery. These are just a few examples of a growing corpus of case law in the biomedical field.